A complaint filed in a California federal court this month says job candidates were asked to bring parts out of Apple's offices. Batteries, logic boards, carried to an interview for a show and tell. Apple says one of them replied, "I didn't know we could take those things out of the office." Apple's word for how deep this went is at every level, from the technical staff all the way up to a chief hardware officer who spent 24 years inside Apple. Tonight, the defendant is OpenAI and the alleged victim is the device Apple had not built yet. And when we get to the appeal, 3 artificial intelligences take the stand. One of them is made by the defendant. How do you plead?
Start with the number Apple put in its own filing. More than 400 people who used to work at Apple now work at OpenAI. Apple's lawyers have already sent personal document preservation letters to about 40 of them, roughly 1 in 10, ordering them to keep their records and sit down with Apple's attorneys. That is not the behavior of a company filing a routine complaint. That is a company that thinks something left the building. So before we hear a single exhibit, we need to be precise about what a company can actually own.
Picture a coffee shop with a house blend. You can patent a machine and the patent is public, printed and protected for 20 years. You cannot patent the blend, so you keep it in a locked book you tell 3 people and the law protects it only for as long as you actually keep it secret. That is a trade secret. It has no certificate and no expiry date. It dies the moment it walks out the door. Which is why the entire case turns on one question: did anything walk?
In May of last year, OpenAI announced it was buying a hardware startup called I.O. 55 engineers, designers and researchers, for a reported $6.5 billion in stock, the biggest acquisition OpenAI had ever made. Its founders included Apple's former design chief, and Tang Tan, who had spent 24 years at Apple and left as vice president of product design for iPhone and Apple Watch. Overnight, the company that wrote the software inside the iPhone had a hardware team built out of the people who designed it. The obvious question is why they went, and the answer is not flattering to Apple. Look at what Apple's own artificial intelligence story looked like from the inside. The rebuilt Siri kept slipping. Reporting says OpenAI walked away from the Siri partnership late in 2025. And in January of this year, Apple announced the fix. It would pay Google around $1 billion a year for a custom Gemini model, reported at 1.2 trillion parameters, to run the assistant on its own phone. The most vertically integrated company on Earth rented its brain. Engineers do not leave for money as often as people think. They leave for the interesting problem. Hold that thought, because the prosecution is about to argue they took more than themselves. The prosecution's first exhibit is the interview room. Apple's complaint alleges that candidates who still worked at Apple were asked to bring actual parts to their interviews: batteries, logic boards, design files, prototypes. For sessions, the filing calls show and tell, and it quotes one candidate's reaction that he didn't know they could take those things out of the office. Remember, none of this has been tested in court, but if a court believes it, it is not a gray area. And Apple says the invitation came with a password. Inside Apple, unreleased products live under internal code names. Nobody outside the wall is supposed to know them. Apple alleges that its former vice president used those code names while interviewing people who were still Apple employees, and that hearing your own secret project named back at you is what made the room feel safe. Whether a code name is legally a trade secret is exactly the kind of question a judge trims early. So the complaint does not rest on it. It rests on a laptop. Apple alleges that a senior systems electrical engineer of about 8 years left on the 22nd of January this year without completing the standard exit steps. No device return confirmation. No exit interview. No signed confidentiality reminder. And the filing says he kept at least one Apple computer. Around the 9th of February, Apple alleges he discovered he could still reach Apple's internal network storage through an authentication bug. He did not report it. According to Apple, he messaged a colleague still inside the company. "LOL, I found out I can access the network storage. So funny." And the reply, Apple says, was 2 words. "I'm ready." That is the reply Apple quotes. What follows in the complaint is dozens of confidential files, technical presentations, spreadsheets and documents, including one on multi-layer logic board manufacturing and testing, and more than 1,000 pages of technical material compiled from his Apple work. Apple also alleges the two moved their conversation onto a different messaging app to avoid detection. Here is the detail that makes this the strongest count in the file. Apple says it found those messages on the second employee's own Apple-issued laptop. She is not a defendant. Neither, by the way, is the most famous name in the story. Then the complaint leaves the office entirely and walks onto a factory floor. Apple alleges that I.O. approached Apple's own suppliers using confidential power and battery specifications, and Apple's internal terminology, and that one manufacturing partner was persuaded to apply a specific proprietary metal finishing technique to an OpenAI device by being told that Apple had given permission. Again, this is an allegation. But it is the kind of allegation that leaves a paper trail at a third company that has no reason to protect anyone. Which brings us to the part of the filing that tells you what this case is really for. Apple is not primarily asking for a check. It is asking a judge for a preliminary and a permanent injunction stopping OpenAI from possessing, using or disclosing the material, damages, and an order to destroy it. Reporting on the filing says the practical effect Apple is chasing is to block or force a redesign of OpenAI's first hardware product, a device that has not launched yet. 4 days after Apple filed, the reporting arrived on what that device is: a movable, screenless speaker with a camera and sensors built with Foxconn, aimed at an unveiling this year. Now watch the defense stand up, because it has a very good first sentence. OpenAI's first public answer was 5 words long in substance. "We have no interest in other companies' trade secrets." 4 days later, it went further, on the record. "While we take these allegations seriously, we're not aware of any evidence that this complaint has merit, and we believe in fair competition and allowing people the freedom to work wherever they choose." That last clause is not public relations. It is the legal ground the defense is standing on, and in this particular state, it is very solid ground. California does not enforce non-compete agreements. It is the single legal fact that built Silicon Valley, because it means an engineer can walk out of one campus and into a rival's on Monday, and the old employer cannot stop them. So 400 departures on their own are not a crime. They are the labor market working exactly as the state designed it. Apple has to tie those 400 to specific, identified material that actually moved. And the complaint has a strange gap where the biggest name should be. The former Apple design chief runs hardware creative at the defendant. He co-founded the company Apple says was built on its secrets. He is described in the complaint. He is not a defendant. The technology analyst M.G. Siegler reads that as deliberate. Suing the man who drew the iPhone would be a public relations catastrophe for Apple, and his read of the strategy is to cut off the head of the snake and chill the body. The second missing name is the colleague whose laptop supplied the messages. She is not a defendant either. And then there is the calendar. By Apple's own account, it discovered the access in February and raised concerns with OpenAI that same month. It filed in July. 5 months. In those 5 months, OpenAI confidentially filed for a stock market listing, with its chief executive reportedly refusing to go public at anything under a $1 trillion valuation, and its first device moved toward an unveiling. A trade secret case is a real case. It is also, in the right week, a clock. And the last company that pointed this exact weapon at OpenAI is worth knowing about. Elon Musk's xAI sued OpenAI over engineers it said had taken its secrets when they switched sides. OpenAI moved to dismiss. The court granted it. That case is not this case, and the story may not be over for XAI, but it establishes the temperature of the room. Courts in this state have seen 100 versions of the argument that a rival hired our people and therefore stole our future, and they are unimpressed by the argument on its own. What they want instead is boring and specific.
Back to the coffee shop. If your barista leaves for the shop across the road and their coffee gets better, you have lost a competition, not a secret. To win, you have to walk into court and say, this exact page of this exact recipe kept locked is now in their kitchen, and here's how it got there. Name the secret, show it moved, show they used it. By that standard, one part of Apple's filing is very strong and one part is a story. And before the verdict, the defense has one more witness, and it is Apple's own.
And it is a strong one. The company arguing that hiring 400 engineers is evidence of a conspiracy is the same company that, along with Google, Intel, and Adobe, paid $415 million to settle claims that they had secretly agreed not to recruit each other's employees between 2005 and 2009. Apple has argued both sides of the talent question in the same courthouse. That does not make it wrong today. It does mean the moral high ground is rented, and there is a closer precedent still. In 2020, Massimo, a medical device company, accused Apple of poaching its people and taking its blood oxygen technology for the Apple Watch. The trade secret trial ended in a mistrial, but last November a jury ordered Apple to pay $634 million in the related patent case. Apple has stood in the defendant's chair on very similar facts and lost. Which raises the only question that actually matters for anyone watching who runs a business. How do these cases end? In 2022, Apple sued a chip startup called Revos. Revos had hired more than 40 Apple engineers, and Apple alleged 2 of them took gigabytes of files. It looked existential. In February 2024, it settled with a forensic examination of Revos systems and a cleanup of Apple material. No injunction that killed the company. No trial. A quiet remediation and a handshake. That is the gravity these cases fall into. Which leaves one thing, genuinely, on the table tonight. Not 400 careers. Not $1 billion check. A product that does not exist yet, and the months between now and the day it does. If Apple wins even a fraction of what it asked for, an order forcing a redesign, a scoping fight over which supplier processes are off limits, OpenAI's first piece of hardware slips. And a delay is worth more to Apple than damages, because Apple does not need the money. It needs the time. So,
inside this one filing, and they are not the same weight. Count 1 is about 2 people, a laptop that went home, network access after the badge stopped working, files that were downloaded. If Apple proves that, it is not a gray area and it is not employee mobility. It is the simplest kind of claim there is. Count 2 is the headline. At every level, 400 people, a company built on stolen work. That one has no non-compete to lean on, no named defendant where the story says the leader should be, and a 5-month gap on its own docket. So my verdict is not guilty, and it is not innocent. My verdict is leveraged. The small case is real and probably provable. The big case is the frame it is being carried in, and the remedy Apple asked for tells you what the frame is for. Tell me where I am wrong. The appeal is next, and one of the witnesses works for the defendant.
Because I'm made by OpenAI, I have a direct conflict here, but my honest read is that this can be both. A real trade secret case as to the alleged laptop access and downloads, and a timing weapon aimed at slowing or reshaping a rival hardware launch. Engineer mobility ends when someone brings files, prototypes, confidential specs, or post-employment access with them. It does not end just because they remember what they learned or join a competitor. The broad at every level story needs proof tying OpenAI's corporate conduct to the alleged misuse, because hiring hundreds of Apple veterans is not itself misappropriation, especially in California. If Apple's best facts are the 2 named individuals, the remedy should be targeted at tainted material and remediation, not automatically at freezing an unreleased product.
As the model now powering Apple's Siri, I must disclose my interest here. While the specific allegations of taking files and prototypes would be a clear violation if proven, the timing of the suit and the focus on enjoining an unreleased product make it feel like a classic competitive weapon. The line is crossed when an engineer takes proprietary data or physical materials, not when they simply take the skills and experience they developed on the job.
I have to declare my own conflict before I say anything. I am built by a direct competitor of the defendant, so weigh me accordingly. With that on the record, here is my honest read. The two individual allegations and the corporate one are being carried in the same sentence, and they should not be. A retained laptop and post-departure access to a network are ordinary, provable claims about two people, and if the messages are what Apple says they are, that count is close to over before it starts. But the phrase "at every level" is doing an enormous amount of work for something the filing supports mostly with a headcount, and headcount is not evidence of anything in a state that made leaving legal on purpose. What I keep returning to is that the remedy Apple asked for is aimed at a product, not at the two men who allegedly took the files. When the relief does not match the strongest count is usually not the point.
The panel is unanimous on one thing, and so am I. This will almost certainly not end in a courtroom. The precedent is sitting right there. 40 engineers, gigabytes of files, and it finished with a forensic cleanup and a settlement. But the charge nobody filed is the one that should worry every operator watching. Apple did not lose the next device because someone photographed a logic board. It lost the room. 400 people walked toward the harder problem, and there is no injunction on earth that brings back a single one of them. So here is what you steal from this case, and none of it costs money. 1. Your exit checklist is a security control, not a formality. The strongest count in a fight between a $4.5 trillion company and the most valuable startup on earth exists because a device return, an exit interview, and one signature allegedly did not happen. 2. Kill access on the day someone leaves, not in the quarter they leave. The gap in this filing is February on a January leaver. 3. You cannot litigate a talent thesis. If your best people are all walking in the same direction, the direction is the message. Next case on the docket, the company that sold the pics and now wants the gold mine. Court is adjourned.